first thing I want to say in this debate as a proud Wellington MP is that I'm glad that it seems that The Hobbit will now be made in this city. I was glad that the Lord of the Rings films were made here. The investment in the city from money and energy and local talent that our local film industry was able to showcase made me really proud. And the New Zealand landscapes displayed internationally through those movies married really well with the 100% Pure campaign that was run so effectively by Tourism New Zealand at the time. And it's also great that a whole range of local businesses did well out of the films being made here. My own former law firm acted for one of the financiers of the films. And I think it's useful just to reflect on the fact that all that happened under a Labour government. And I hope that we'll see similar benefits that we saw from the Lord of the Rings movies, from the Hobbit movies, including a boost to our local filmmaking industry. But, Mr. Speaker, there's a big difference. The Hobbit movies, thanks to the mismanagement that we've seen from the government, come at a great cost to this country, one that New Zealand didn't have to pay to have the Lord of the Rings movies made here. Because the government proposes to rush through, under urgency, all the stages of a completely unnecessary law change through the House today and tomorrow. There'll be no select committee scrutiny of the legislation. There'll be no public or expert submissions heard on it. There'll be no advice from officials to members on the amendment. Mr. Speaker, I just want to explain to the House, read into the record, to quote the words used by the attorney, why this amendment is unnecessary and undesirable. And I hope Mr. Flavel listens, because I think his speech was an extraordinary example of how you can actually advocate for something by using all the reasons that undermine your advocacy for taking the position that you do. As Christopher Finlayson told the House, I was a member of the legal team that acted for the Council of Trade Unions in the Supreme Court on the Bryson and 3'6" litigation. And I was really proud to accept their instruction. He seems to think that's not a matter of pride to be available to your clients, to take their brief. He should know, as the leader of the legal profession, that there's no more sacred duty on a lawyer than to do that when approached. And I was glad to argue the case. There was fantastic argument in the Supreme Court, and the Supreme Court listened carefully to the issues that were presented to it and dealt with the matter very carefully. And it's useful because we heard a complete mishmash of a summary from Jerry Brownlee as to what actually happened in the Bryson case. Here are the facts. In that case, a model maker had worked variously for Weta Workshops and 3'6". So 3'6" was a company specifically established to administer the production of the Lord of the Rings movies. During the production of the movies, Mr. Bryson worked fixed hours, 7:30 or 8 a.m. to 6 p.m. or 6:30 p.m, with 45 minutes for a lunch break every day. He was part of a crew of 42 working similar fixed hours. He worked only for Weta and for 3'6" Limited. For his first few weeks, he received on-the-job training in what he was supposed to do for Weta, and he got an individual initial pay rate of $18 an hour. These are the classic indications in our law of the existence of an employment relationship. But 6 months in to that relationship, Mr. Bryson was given a document by 3'6" Limited, in common with the rest of his crew, referring to contractor and independent contractor. So those are the facts of that litigation. The long and the short of what the courts decided to do. That's right, 6 months in to the relationship, it was 3'6" who proffered a document misdescribing the relationship as one of an independent nature rather than of employment, which it clearly was. And that's what the Supreme Court confirmed in the litigation. Despite handing Mr. Bryson a document describing him as a contractor, he was clearly an employee by every test known to the common law and applied in this and every other common law country for over the last 100 years. The Supreme Court also confirmed that if the parties had bothered to clearly and correctly label their relationship from the outset, New Zealand law provides all the flexibility for them to choose whether to be in an employment or a contracting relationship. Mr. Speaker, this bill won't actually fix anything. There hasn't been a flood of litigation since the Bryson case. In fact, that is the last leading case, 5 years old, on the question of how you determine in this country whether a person is an employee or a contractor. So much for the great doubt that is said to exist in our law on this point, to be some sort of block on incoming foreign investment that we are said to need so badly in this case, that we will do anything, including subvert the processes of this House, to change the law in order to accommodate a foreign investor. But the problem in this legislation, the amendment as proposed by the Minister, will be apparent to any employment lawyer looking at the provisions of the legislation. Because in any case where anyone asserts that they're in an employment relationship, and this is under the proviso in clause 4.2 of the amendment, the court will still have to undertake the very exercise that it undertook in the Bryson litigation. Because what the proviso says is if there is an employment relationship, or if the person complaining is a party to an employment relationship, then they are not subject to the exclusion in the amendment. They will be subject to employment law. Well, how does anybody determine whether or not the person is subject to an employment relationship? They go through the tests that the court had to go through in the Bryson case to determine whether or not an employment relationship exists. And that is the recipe for litigation that this Minister is creating in this rushed and botched legislation. Far from creating some sort of certainty that is said to be sought here, we are participating in the creation of massive uncertainty by unleashing the very sort of inquiry that the Minister thinks she's going to extinguish on the courts and on the parties to litigation in these sorts of disputes. Because, Mr. Speaker, as I say, the courts are going to have to go through the mixed inquiry of fact and law to determine whether or not, in any case, an employment relationship exists. An employment contract doesn't have to be in writing, as the Bryson case made very clear. They have to go through the tests, look at the reality of the relationship, determine whether or not, in any case before them, there is in fact such an employment relationship. So every time after this House rushes this legislation through, every time there's a dispute in the film industry, what's going to happen? A person is going to say, I'm an employee, I'm subject to an employment contract. They're going to do that because it's cheaper to take a personal grievance than it is to take a commercial dispute through the ordinary courts. And then the courts or the Employment Relations Authority are going to have to do exactly what they did in Bryson. So what this Minister is doing, through her inexperience and her lack of knowledge of employment law, and her failure to seek the most basic advice and follow the most basic process. She and the members opposite think it's funny, but actually what they are doing is they're about to put employers in this country through a major new series of employment litigation, which has not been seen for 5 years in this area, but which they will be responsible for resurrecting. Mr. Speaker, we're tying ourselves up in knots. We've sacrificed our sovereignty. We've thrown out due process, all for an amendment that simply will not do what the Minister thinks it will.